Ms Legalista here. Welcome to the video. I'm going back to the hair relaxer lawsuit. Now, I tried to record this video. I actually did record it. I had editing issues. It just didn't work. I finally figured out what the issue is, but now I've had to do the whole video back over. So here we are. The hair relaxer lawsuit came about mostly after this medical study that found that women who used chemical hair relaxer products had a higher risk of contracting uterine cancer. Well, a lot of women have now submitted claims, and this lawsuit is moving forward. People from across the country have submitted claims, and so we're calling this multi-district litigation. That's not really what I want to talk about in this video. What I want to talk about is why I feel like the judge was mad. Mad, I don't know if that's the right word to use, but I think she was obviously feeling some kind of way. And let me bring up this lawsuit so that I can tell you exactly what was going on with this motion to compel. The plaintiffs had sent the defendants some questions. Here are some questions that you have to respond to. Defendants, one in particular, you're going to have to see what they responded with and what the judge said. Now, this is only 6 pages, and I'm not going to go into the whole 6 pages. I'm really going to try to highlight the pieces of this that I think are most important. But let's start at the beginning here. This is coming out of Illinois, the Northern District. This is Judge Mary Rowland, and you can see the title of this lawsuit: Hair Relaxer Marketing, Sales Practices, and Products Liability Litigation. And you can also go back and check out some of my previous videos on this. So it says here, plaintiffs move to compel defendants, and you see the defendants listed there, one of which is L'Oreal. L'Oreal. I think I'm going to be talking about L'Oreal. I may have said Revlon. I keep going back and forth. Look, it's been such a hard day already. Plaintiff's motion is to compel L'Oreal to respond to these questions. And I'm going to go down here with the analysis piece. And then I'm also going to do another video that talks about what L'Oreal actually said. We're going to hint on it a little bit here, but I want you to follow along with this because it really does get to all of this extra stuff that L'Oreal tried to say, but not answer the question, okay? They put in a lot of fluffery and did not answer the question. They weren't very clear about it. We'll see. We're going to have another video on that. Okay, so it says the dispute here involves L'Oreal, and let me make sure that I'm looking at this like I hope I'm looking at this. Yeah. The dispute here involves L'Oreal's responses to interrogatories number 2 and 3. So just 2 questions. The questions are straightforward. Okay. The questions are straightforward. This is what the judge is saying here. The questions are straightforward, not trickery, not convoluted, not something where you got to go do a whole bunch of research on because you don't even understand what the question is asking. She's saying, no, this is not the case. The questions are straightforward. And here they are. Plaintiff asks L'Oreal to provide each of the brand names under which L'Oreal made hair relaxer products available for sale or distribution. And then for each brand, L'Oreal is to provide each product made available for sale or distribution. You get that, right? Okay. Tell us, L'Oreal, what brands you have, and then for each one, what the products are. Now, if you're familiar with relaxers, you know that some company might have 3 or 4 brands. And then for each brand, for the relaxer, it'll be, we have the mild, we have the one for coarse hair, we have the one for curly hair, we have the one for color treated hair. So you got all those different products under each brand. That is essentially what they were asking L'Oreal. So you would think a company would know, right? It says the problem arose. Let's go down here to the bottom. The problem arose because, according to the briefs, L'Oreal identified products sold by limiting review to its records from its finance department. So they said, well, we're just going to go over to finance and get that information. Pursuant to the company's retention policies, these records date back only to 2007. Therefore, L'Oreal identifies products it distributed back to 2007 only. Okay. It says there is no dispute that in other productions, L'Oreal has produced documents that identifies products other than those that they listed in their response. So they've already turned over information saying, here's a list. And then for this interrogatory, they said, here's a list. Got me? It says the debate then is whether L'Oreal is required to review documents other than financial documents to identify all brands and products sold during the relevant time. The court finds L'Oreal must identify all relaxer products it is able to identify through a diligent search. This means you can't just run over to finance department and say, hey, give me what you got, and then be like, okay, I'm done, because that's all I'm going to do. The court doesn't consider that to be a diligent search, okay? This includes searching documents out of financial documents dating to 2007. Isn't that what I just said? As the court has already found, this is highly relevant information. I want you to remember that. Highly relevant information, because they also are going to bring in some totally irrelevant information. The interrogatories request information about items made available for sale distribution. There is nothing limiting L'Oreal's duty to search financial documents. Advertising and meeting minutes could and likely would contain information about brands and products available for sale and distribution. And then they also say that they had given some of this information before. If we scroll down to the bottom of this page, you can see exactly what I'm talking about. Look at all of these different brands and the products under the brand. So you have the Band 2 No Base Relaxer would be the brand, right? Then you have regular strength, you have super strength, you have mild strength, and then another brand would be Dark and Lovely Beautiful Beginnings. And then you have the, for all hair types, you have the Curl Softener for all curly hair types. You have the Shea Moisture. So you can see what they're talking about. They're saying for each brand, tell us, first of all, tell us all the brands you have, and then for each brand, tell us all the products. You would think a company would know that, right? It would not try to hide that. Before turning to the next motion, the court must observe the extent of the irrelevant information contained in the response. This is why I said the judge, I think the judge was feeling some kind of way having to even respond to this. It says L'Oreal's 9-page response to interrogatory number 2, 9 pages? To interrogatory number 2 is akin to watching a PBS special on the development of Black-owned hair care industry. The company's founding in 1953 and its enduring commitment to self-expression, acting responsibly and ethically, and protecting the environment. Then the history lesson begins when the reader learns the story of George Johnson, the son of a sharecropper who sold homemade hair products from his station wagon and founded Johnson Products. The judge is like, what does this have to do with anything? Johnson Products is a well-known Chicago story, and Johnson's success in the face of entrenched racism is to be admired. Why do we think they put that part in there? But the court wonders why this information is included in response to interrogatory number 2. I'm wondering too. The court did not know the story of Carson Inc. Apparently one of its employees escaped Castro and its invention of Dark and Lovely, nor the fact that Dr. Keith, the 8th president of Morehouse College, misspelling, made the decision to invest in Carson. But again, what is the point? Next is a compelling story regarding the development and growth of Soft Sheen Products, Inc., another iconic Chicago business. The interrogatory response shares that this entity contributed to Mayor Harold Washington's campaign. What does that have to do with anything? It is interesting to know that these 3 black hair care product giants have all been joined under the L'Oreal corporate umbrella. But for purposes of this litigation, what is more important to know is that the parties need to get straight to the point. She said the parties need to get to the point. In other words, stop with the fluffery. And this is a heads up because they haven't even really gotten to the point of being in the trial yet. They're just passing paperwork back and forth and asking questions. This is called discovery, getting all of the facts and evidence. And she's saying, hey, okay, yellow light here. This is not how this is going to go. You are not going to be answering things with a whole bunch of fluffery. So be prepared that the day that you show up in court and we start this trial, I expect you to get straight to the point. And I'm going to take a look at that. I think I recorded it already. I don't think that one got messed up. But she's right. She is right. I'm going to read it to you. There is all of this unnecessary stuff, fluffery in there, and it does make you ask the question. L'Oreal, I'm sorry, but for what purpose are you trying to include this information? Are you trying to get people to forget about the fact that this product has chemicals that's been linked to uterine cancer? And so let's talk about the Black people who founded it, and maybe people will forget about that part. I don't understand. I mean, when I read it to you, you will get it. You will get it. It is so off base. It has absolutely nothing at all to do with this litigation. So stick around as I continue to break down what's going on with this hair care relaxer lawsuit and dig into the facts and what is going on. All right, don't forget to subscribe. Don't forget to like the video. Mwah. Peace.